Hello viewers, welcome to our program Immigration and You. I am your immigration attorney Michael Phulwani, and once again we have with us attorney David Nachman. Mr. Nachman, welcome. Now before we start the program today, let us remind you that today is the India Day parade, so go attend the parade, enjoy, have fun. And with that, let us start a very interesting program for which I know all the viewers ask questions all the time. Now, in our US immigration law, there are a number of reasons or grounds of ineligibilities, as we call them, based upon which the applicant, whether it's a migrant visa or a temporary visa, can be denied the visa or can be refused admission into the US. So in today's program, and hopefully we may continue the same further discussion in the next program as well, we're going to tell you about each ground of ineligibility, how it can be overcome, and in some cases a waiver may be required, and in other cases the waiver is not even available. So you must know all these things, because what happens is, David, this is very important that I want to tell our viewers, that there are many lawyers who don't do what you and me do, going from the starting point to the ending point. In other words, they say, okay, you got married, give me the money, and the Form I-130 filed. And then this one of these problems come in, oh, I didn't know that, you didn't tell me. And then many cases, I say, why you did not lawyer? He said, you did not ask me anything, I don't know, I'm not a lawyer. So that's the reason that we are doing this program to our viewers, that if you are starting any immigration case, you must think of what the problems are first. I mean, easy. Oh, you are married to a citizen, so you know that you can apply. I don't want to spend much time in telling you that. You already know it. What I want to say is that we should see where are the hurdles, what are the problems, the journey from start to the finish. There are going to be some bumps, there are going to be some problems, some small, some serious. That's what we are going to talk about today, so that our viewers understand that, I mean, basically, you are always welcome to come to us for help on immigration matters. But I'm saying, even if you have already an existing attorney, you are working on the case, it's a good idea to talk to your lawyer about any problems, even if you started the case. Go and talk to him. Oh, by the way, I just wanted to tell you, a year ago I was arrested for shoplifting, or I have a previous deportation order, or something happened, they took your fingerprints. A lot of people say, oh, nothing happened thereafter, but that's not the issue. The issue is there's a record created already in the record that may be considered something that you are ineligible to get this visa. So with that,
it's actually a very good point, Michael, because when we're doing the initial intakes, as we do in our offices, we always encourage our clients to tell us everything. And the clients sometimes feel that it's better not to tell us something, and then what ends up happening is it becomes more of a problem later on if they don't tell us. But if they tell us up front that they have a particular issue, we're able to deal with that issue by filing for a waiver or by dealing with the issue up front. And that is the value that we can impart by knowing the complete case.
David, very good point. I tell you, not too many cases because we go up front. There were some cases where in going up front, they did not tell the truth. For example, the person got an immigrant visa as unmarried son or daughter of a citizen or green card holder, but he was actually married prior to that. So in a way, there was some fraudulent thing. So I say, but when you came to give me the case, you never said anything about that. You said you were unmarried. As of today, the day you met me, you say you were unmarried. Why you did not tell me the truth? Oh, I was afraid. I was afraid of what? I mean, basically, if I would have said I won't take the case, it's better than now that we have already said that, and now we have got to somehow retract or try to see what we can do about it. So with that, let us,
And one additional item is that, for example, if a client comes in and says, well, I had a problem at the border many years ago, or I had a case where I was stopped at the border, I was previously deported from the border, we can do a special process called a FOIA request. And we can use the Freedom of Information Act in the United States, which is part of the law, to get information, to find out what the government has in its files. And that's very valuable to us because we can anticipate what the problems might be and deal with them.
Not only that, basically, The client tells, yes, I had a previous deportation, previous crime, previous problem with a marriage or with fraud or misrepresentation made to an American consul in connection with the visa application, anything. So we know that we have a problem. So at the time that we are starting the case, I tell the client, listen, there is a deportation order, it's going to be a big problem. You committed some fraud or misrepresentation, but your wife is a citizen, you have children, we will go ahead with the case, but definitely it is going to require a waiver. So he's ready, even from day one, or he was previously deported, now he's living in India, we say, yeah, we have to apply for permission to, reapply after deportation, the Form 212 form or a 601 for waiver. So he gave a full picture, complete picture. This is what we can do. After that, this is what is going to happen. And in some cases, we cannot, most cases, we cannot guarantee. Waiver is, for example, a purely discretionary on the part of the officer. But we can say the good case. Either the officer, citizen, children are there, extreme hardship factors are there. The psychiatric problems, the physical problems, we evaluate a case. And then we take the case, and then the client doesn't have a reason to complain. Because he was told the day one that this is what's going to happen.
Absolutely. And what it's all about, Michael, and I think you would agree, is it's about expectations. Exactly. It's about making the expectation and helping the client to understand what those expectations are, because later on, the amount of work that your lawyer, that our offices put into the case for the client has to do with the price that they're charged for the case. So if we understand what the potential issues are ahead of time, we can at least give them a reasonable cost assessment for what their case is going to end up being charged.
With that, let us start giving them the grounds of ineligibility under the U.S. Immigration and Nationality Act. Let's start. There are many of them. I don't think we can really complete in today's program, but if we cannot, we will continue to discuss further in the next program. So let's start at least. Health-related ground. Now, one of the things that is common in that is a communicable disease of public health significance, like a tuberculosis. Now, you know that before issuing an immigrant visa, the person has to go in for a medical exam, and the X-ray report may show that there is some spot that appears to be a tuberculosis. Consul will not issue the visa, put it, deny it, put on hold. Now, so most of these grounds are can be taken care of. In other words, you can get around them by waiting some period of time, by taking some treatments. Many cases I've seen tuberculosis, they went for a treatment, they were cured, they take another X-rays and they say, no, it is all done. Or it's an old spot, then they say, okay, come after 3 months again, and then again they see it's not active. Something that happened many years ago and it stays there, that's okay. Right. So those are the things that happen. HIV, for example, which now almost is gone.
It's not an issue. It's been taken off the list.
It used to be, until recently, HIV one of the issues, and then HIV needed a waiver.
About 6 months ago, it was taken off the list.
We did many cases HIV, but needed a waiver, and waiver was granted mostly.
That's right.
The vaccination is something the person doesn't have the vaccinations as required. So that's easy. Take the vaccinations or show the proof of vaccinations, and then you can proceed with the case. There's something about mental problems. People have mental problems. And it's not like somebody has mental problems, he's non-violent. That generally is not a problem. But it's a mental disorder which is associated with harmful behavior. He's likely to kill himself, kill others, and that kind of problem may again be something that can put on a hold. It may be year, 2 years down the road, he takes treatment, he's taken cured of, then he may still be able to get. So this is not as bad as some of the other things we are going to continue other. Criminal-related grounds. A person committed a crime, and based upon that crime, depending on what the crime is, what the punishment is, this is a misdemeanor, is it a small offense, it's an offense
felony, not aggravated felony,
or something that is not it's considered a petty crime.
De minimis.
De minimis, so it depends on that, and some of them, like drugs, for example. That's also dealing in drugs, using drugs is something, a criminal case. You want to tell something more about these kind of crimes and whether waivers are available in those cases?
Well, I think that the most important thing about any criminal matter that comes up in the immigration context, Michael, and I think you would agree, is that a full-blown analysis really needs to be made. And we need to look at the criminal action both from a state and federal level. We have to check the state law and see what exactly the person has been charged with. A lot of people think that for criminal actions that they're told by their criminal lawyers that these matters can be expunged. Unfortunately, the way it works is that expungement doesn't work for immigration purposes. That criminal conviction is a matter of record. It stays on your record and it never goes away. And so we then have this additional overlay of administrative bureaucracy, I guess, if you will, in this new case that recently came out. It was about a year ago in Padilla, where individuals were supposed to have been told about what the implication was of their conviction or their pleas that they took in court.
What you are saying, David, that many times you got a small crime, something which is bad for immigration purposes, but your criminal lawyer says, plead guilty, as with nothing, fine, little bit fine.
Not to worry, it's not a problem.
Why you want to keep fighting? Small thing. But pleading guilty may be a big problem on the immigration consequences. So we always advise that you have committed a crime or you are charged with a crime and you are a lawyer that is handling your case. Tell him to consult a good immigration lawyer, or you can arrange like one of us or any other your own immigration lawyer to talk to the criminal lawyer. Criminal lawyer must understand the consequence of immigration, and then he may plead guilty or not guilty. And if he pleads guilty, maybe something like a disorderly conduct or some little thing which does not have effect on. So there has to be a coordination between the criminal lawyer and the immigration lawyer.
Exactly. More and more we're being asked to consult with criminal lawyers to tell them exactly what the immigration implications are of the pleas and convictions.
Now, if let us say that if the criminal conviction that is inadmissibility, there's a waiver available after 15 years from the date that the crime was committed, is possible to then get a waiver easily, or exceptional hardship ground. That's why if the citizen, children are there. Mostly these are the two reasons that you could. But again, we make this determination on a case-by-case basis. Person says, this problem is there, what's going to happen? I say, bring the copy of your disposition and let us see what the crime was, what the punishment was, and we, in consultation with the criminal lawyer. There have been cases where they go back to the criminal lawyer to make an application to reduce it, to change the nature of the conviction and the consequences.
Right, and that's called post-conviction relief.
Exactly.
Where they go back, they reopen the case, and they try to get it bid down, if you will, to a lesser offense. And that's another form of relief. Michael, you raise a really good point, something that we always tell our clients: bring the disposition letters with you, bring the police report with you, bring the information to our office, let us review it, because oftentimes people show up to our office and they have multiple offenses and they don't bring these documents, and we then have to send them back to get these documents, which takes a tremendous amount of time. So it's always best for our clients to come to our office with all of the information ahead of time so that we're able to do a complete analysis.
So, okay, the second one is security and related grounds. Now, again, there are separate types of security issues.
It's a multifaceted analysis.
Yeah, like basically if a person is a member of a certain group and that group is designated as a terrorist group, the question is whether this person was simply a non-active member or an active member. Each case, again, has to be evaluated on a case-by-case basis.
Are they giving material support?
Yeah.
And that's...
However, I'm just telling you, the recent developments in the security issues is that if a person is on the no-fly list, is on a security clearance list, many times I've seen that, person is innocent, he has not done anything at all. The different thing I'm talking about. But his name is same or similar to the one for which this information is put in the computer. Because when you apply for an immigrant visa, at the consulate or any other visa these days, you are fingerprinted. And based upon that, it will be a hit in the computer.
That's right.
The computer says clearance needed, consul cannot issue the visa. And consul doesn't even tell you what it is. Administrative processing is a code word for a lot of we understand. And based upon the interview, we find out that the applicant or client doesn't need anything to give further because he has been told we don't need anything, just have to wait. I know what that means. Right. So that, unfortunately, in most cases, you have to be patient and wait until the security clearances can be obtained. But you can always call us to see whether we can provide some assistance in those cases as well. So with that, you have a last word.
Well, I just wanted to mention, Michael, and you pointed out that there are various levels of security clearance. There's the technical alert list, Visa Donkey, Visa Eagle. These are all regulated by the U.S. Department of State. And again, a full-blown analysis should be made as to what the potential implications are for each.
With that, we thank you very much for watching the program. David, thank you very much for being the program. We have a lot more to talk about these ineligibilities. And I think we should continue this discussion, our next program. So make sure to you watch us next Sunday at 11:15 a.m. Thank you very much and goodbye. Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Phulwani, and once again we have with us attorney David Nachman.
Hi.
Now if you remember, in our last program we were discussing about various ineligibilities based upon which a person can be denied admission in the US or denied a visa, because there are a number of grounds based upon which a person can be found ineligible, whether it's a permanent visa or whether it's a temporary visa. We just discussed about few of the items in our last program and want to continue further and tell you more about the grounds of ineligibilities and if waivers, if they are possible, because remember, not every category there's an automatic waiver or waiver even available. So let's continue with that discussion. One of the other grounds of ineligibility is illegal entrants and immigration violators. Now, illegal entrance, when we say people cross the border without a visa, some people come with hamshakal, saying, but hamshakal means same face, same look-alike. That's a fraud. But I'm just talking about illegal entrance without a visa are people that overstay, they violate the laws. And they mostly those people are not eligible to adjust their status unless, of course, they qualify under section 245I. I don't know how many times we have talked about 245I on this program. Basically for those people who applied for a immigrant visa petition or a labor certification before January 1498 or before April 30, 2001, the little difference in those two categories. And we don't want to spend much time on that. You guys already 50% immigration lawyers by watching our program. So these kind of persons, as I said, are barred. It's ineligible except if they have a 245I or if they are battered spouses or children which are battered. So that's also an exception. So that's about the illegal entrance, and hopefully we are hoping, David, for many years that there might be some change in the law. Unfortunately, I have seen cases, person is married to a US citizen. US citizen. He got 2 US citizen children. He came without a visa. And unfortunately, over the periods, he had an opportunity to apply for 245I or even to file a petition based upon I-130. One particular client, I said, you are married for so many years. Why did you not file a petition in 2001 when this law came in? I-130. He said, I was afraid. I mean, you see the things in the big cities, New York, New Jersey and California, Los Angeles, they watch our programs, they meet people. There's some small towns in USA where a person has no information or knowledge, no contact with anybody. He's worried, quietly sitting in the corner, working, making some money, handling. He doesn't want to rock the boat. He doesn't want to say a word. So one of those clients, unfortunately. But we've been trying to see, at least get some kind of relief for people, like including them in a 245I automatically without the date, whenever, or just move them into section 245A, that even if they entered, but if they are married to a US citizen, have children like that, or some category, and not too many number of people are there, but these are really people that we really think that are deserve some kind of relief in this case. And actually I talked to Senator Menendez on this subject also, and he said that whenever he gets a chance in another bill, he may at least put this little thing. I don't think there may be few thousand people only in that category. So let's see what happens on that. Big one is 212A6C. That is the fraud and misrepresentation. I'll tell you, majority of the denials that happen in these categories is the biggest one. And this comes from many sources. A person previously applied for a visa and he lied something based upon his job, based upon his experience, based upon marital status, based upon whether you are divorced or not, anything. That really it was able to get the visa, or even it was denied a visa, but he tried to get it based upon a fraudulent misrepresentation or fraudulent documents also. The fraudulent birth certificate, fraudulent marriage certificate, unfortunately we've seen lots and lots of them. And David, you have no idea how many times I have come on this program and told our viewers, don't do a fraud, don't do a fraud, don't do a fraud. And then we see again happening all the time, unfortunately. But the fraud and misrepresentation is a lifetime bar. Once upon a time when I started practice many years ago, the bar was only 10 years. And after 10 years, you can apply and you can automatically get it.
Right.
And then they changed the law and made it lifelong bar. However, the good news is that there is still a waiver available. Waiver Hindi mein bolte hain, Hindi se maafi nama, like forgiveness. A petition, forgive me, sir, because my petitioning spouse or a parent or who filed the petition is going to be subjected to extreme hardship. Extreme hardship is very, very important for getting a waiver, because people say hardship, I married my wife, citizen, but that's not exceptional. Everybody says a married wife, I married a citizen wife or a citizen parent or a green card holder parent. Just having a relative qualifying doesn't get you the waiver. You have to put in a lot of good information, document psychiatric reports, physical problems and the medication, and the family, how many family members are here, how much is in India. So this is what works on the waivers. But again, the waiver itself is a big subject that we can talk about 1 year just on the waivers. But let's move along, otherwise we'll never complete the list. You got anything to say on this?
Actually, I agree that it's a very, very high legal standard that needs to be met.
You can even talk about a little bit on the fraud misrepresentation that takes place in the business cases. H-1Bs, L-1s, immigrant visas, labor certification.
Absolutely. Well,
what kind?
Well, we have the same issues that come up, and if an individual has committed fraud, it usually begets an investigation in the business context. Needless to say that there are all kinds of investigations going on by the Department of Labor, by by CIS, FDNS, Fraud Investigation Unit. So these are basic, and they're rooted in.
Yeah, people put in false experience letters. They put in false degrees, diplomas,
and as simple as an employer saying that they're going to pay the prevailing wage and failing to do so. The highest fraud levels, I guess, were seen in the religious worker classification, where they went back and did an investigation of how many religious workers.
A small church like this, 4,000 religious petitions. I mean, come on.
1/3 of the total number of religious workers were subject. Yeah, it was incredible.
So that's
numbers.
Now, in terms of waivers, I must tell you that person has to have qualifying relatives for waivers. For who are the qualifying relatives? Generally, it is a U.S. citizen or green card holder spouse, that means wife or a husband, or a parent, not a child. Once upon a time, the child was there, but now several years ago, they took the child out. So person says, my son is going to be extreme hardship, it's no good. My father, mother hardship is okay. My husband, wife hardship is okay. So that's very important for you to have a qualifying relative in order to apply for the waiver. Getting is another thing, because it's discretion. People get mad, oh, I applied, I spent so much time and work, and they denied. I say it's not a right because you filed and you paid the fees, the government has to approve it. Discretion means they have to evaluate the whole case, all the reports, and make a decision. There is going to be a real hardship or not? Is this a hardship? Is it exceptional? So that's the way the waivers work.
Well, Michael, one other important thing is that we should let the viewers know that just because a waiver is denied doesn't mean that that's the end of the road, that they can ask for reconsideration and that they can go up and ask for it to be re-reviewed. So that's something
Ultimately, if the waiver is approved, whether an appeal, whether it's an motion, then the case can go further.
That's correct.
Otherwise, they can maybe consider a Canadian option in a way. Anyway, so one of the other grounds is Section 212E, as we say, smuggling. Now, somebody is involved in smuggling, then that is a ground of ineligibility. Very bad, worst thing. Because, and also let me say, smuggling is, people think smuggling means putting somebody, relative, friend or some person in the trunk of the car and bringing in. That is smuggling. I didn't do nothing. All I did is, just give us a birth certificate of my child. He was over 21. I just changed to under 21. It's not only a fraud. It's a smuggling charge. Because this parent wants to smuggle a son who's not eligible. It's not smuggling, but under the law, they consider smuggling. He's trying to get an immigrant visa for a son and bringing some to the U.S., even if he's ineligible to enter the U.S. legally. So people don't understand. You see, there's a lot of pressure in our Indian families, right? A family is immigrating. The brother, father, sister of the wife or somebody puts a pressure on the family. Please include my son also. Include my son. You are going anyway. You have 3 sons. Consider this as your own son. You love him like your own son anyway. Just put him in the name and just create a phony birth certificate, and that is smuggling.
Right.
So what happens if the smuggling charge is not just that child is denied, the whole family, the person for whom the petitions filed, the wife, the children, everybody is denied. And the council are very smart. Council, they call the whole family, and one by one they ask him the question, is that boy your brother? He says yes, because he knows that the family has applied for him. Yes, yes, yes. And they put a 60 charge fraud on them also and the wife also. Very serious consequences. Is there a waiver available? Limited waiver available. The waiver is available only, it's not available in the 4th preference category, the brother, sisters, not available. But other categories, it's available only if the person is trying to bring his own son or wife, own child, I'm sorry, son, daughter or wife. By some misrepresentation, he's trying to bring, and then the smuggling charge comes out of that, and there may be a same 601 waiver available for showing extreme hardship. Student visa abuser. This was a recent one that few years ago they said that whoever aliens who violate the terms of student visa are inadmissible for 5 years. So with that, I think, let's see, we have more time.
That's an interesting issue in light of the University of Northern Virginia case, yes, and also the case out of California, right?
Correct, yeah, correct. Now, the other issue is, which can be overcome in most cases, a public charge. Because under the law, if a person is likely to become a public charge, like getting Medicaid and welfare, is likely to become, the council can deny the visa, or the immigration can deny any benefit. But now that they've relaxed the 864 requirements, that if you don't have the income, another joint sponsor can give the affidavit or support. Doesn't even have to be a relative, even a friend or some family member can give. It has relaxed a lot. So most people are able to get around it by complying with that regulation. It has become much less and less and less and less. Okay, this is a technical reason that you can talk about. Labor certification required and licensure requirement. If a person has to have a labor certification, if he does not have a labor certification, the law says that he is not admissible as an immigrant. I mean, if he's not, forget the family preference category, under the employment preference categories, most of the categories they require to have a labor certification, and in absence of a labor certification or not having a labor certification is a ground of ineligibility. And also license requirements. How do you explain the license requirements? That a person doesn't have a license, he cannot be admitted, even if he is a nurse, even if he is a doctor. The law, if the law requires the license, then otherwise he's inadmissible.
Correct. They have to have the license. Right.
So basically, what kind of jobs?
Not for H-1B non-immigrants.
No, if the job requires a license,
right,
that's it.
Right.
If there's a H-1B nurse, for example, he needs a license. H-1B may be some other kind of research, medical doctor.
They'll grant them a temporary period of time in which to obtain a
medical
license,
doctor wants to doing a research,
right,
then there's no license,
required. Yeah.
Now, this is another very common, but people easily go around